And these things kind of piece together. I mean, that's essentially an immigration authority, not a lethal authority. But if you step back, where they connect is the Trump administration essentially building a theory or relying on a theory that the United States is at war with Tren de Aragua, possibly in some way also Venezuela. And not a war in a rhetorical sense, but an actual, I mean, in legal terms, we'd say armed conflict.
Matt Waxman, welcome to the show.
Good to be back.
Well, we're great to have you back. As our listeners and viewers may recall, you are a professor of law at Columbia University, and you come to the world of the academy and law schools from deep experience in the national security and foreign policy community, which makes you uniquely qualified to direct Columbia's national security law program. We're not going to talk about the world of higher ed, as we've done in the past with you as a guest on Reaganism. We're going to talk about current events and really draw upon your time in the Bush administration. That's the George W. Bush administration, where you had senior roles in National Security Council and the State Department. I'll also note you are a senior adjunct fellow on the Council of Foreign Relations. What I want to do today, Matt, is talk about the Trump administration's recent strike on a Venezuelan gang known as Tren de Aragua in the Caribbean Sea, which got a lot of attention both from the policy community, that is a national security policy community, the political commentariat, as well as the legal community. And if you don't mind, maybe just starting out, tell us what we know, because as a legal professional, facts still do matter there.
Yeah, so thanks for having me. So as you alluded to, last week, a week ago today, the Trump administration conducted a lethal strike against an alleged vessel being crewed. The Trump administration says 11 people on board, members of a ruthlessly violent transnational gang that's been spawned in Venezuela. Tren de Aragua is an organization that the Trump administration had previously designated officially as a foreign terrorist organization. The Trump administration also describes it sometimes as some sort of arm of the Venezuelan government, the Maduro regime. Although it's been inconsistent on that, and I'll just note the intelligence community doesn't seem to back that up. But the Trump administration conducted a lethal strike in international waters in the Caribbean. And it was described as intended to send a message, both to the gang itself, to the Venezuelan government, and I think to other actors in the region. Roger, as you said, there are a lot of facts that we just don't know here. So, and the administration has said relatively little about the sort of the legal framework that it's applying. So I'm going to talk based on some educated guesswork here, but I do also speak as somebody who has defended a lot of targeted killing in the context of the global war on terror, or I think more precisely, it's good to call it refer to it as a global war against Al-Qaeda, and also as somebody who takes a pretty broad view of the president's powers under Article 2.
So two things you've just said there make you somewhat less squishy on these issues, or perhaps less, open to the idea that as a matter of law, the President of the United States is able to carry out these strikes, certainly against Al-Qaeda and its network, and targeted strikes that have happened in the years since 9/11. So all that should make a skeptical listener perhaps less skeptical about Professor Waxman's perspective on this. But it sounds like you're going to come down maybe in a different place than you would have if this would have been an Al-Qaeda fast boat in the Caribbean Sea.
Yeah, I'll say that. Coming from my own background, having worked on the legal and policy framework for the global war on terror, I see this as very different. I would defend targeted strikes in the war against Al-Qaeda but I'm very skeptical of applying a similar kind of legal framework based on what we know to Tren de Aragua.
Okay, so let's talk about that for a second. Again, I'm happy you clarified that sort of the skepticism is driven by a legal analysis, perhaps not on the policy analysis, and maybe we'll get into that as well.
I'll contest the policy on the merits too, and
right.
And there I'll just say I have some broad concerns about what it means for American defense posture.
Right. Okay. So we'll talk about the policy, but let's start with the legal side because it's interesting as lawmakers and policymakers in the commentariat absorb this news following the post on socials, where it's Truth Social or X or any other that picked up on this. He was like, "Well, is this lawful?" And a couple of things on this. When we talk about lawful, there are a few categories. Is it legal for President of the United States to do it within the bounds of U.S. law, the Constitution and statutes? And then there's international law as well, and there's some interaction between the two. I came out shortly after. I had a Fox hit, and I think I did call you up and say, "Hey, Matt, here's what I'm thinking about. Here's my hot take. Make sure I'm get sort of some feedback on it. Not that you were in any way endorsing what Zakheim was saying." But at least in this case, I was making sure I was, consulting or at least getting different perspectives before spouting off. But my view was, hey, there's broad authority under Article 2 of our Constitution, the Commander-in-Chief authority, for the President of the United States to take military action, apply lethal force, if the President of the United States determines that this target threatens citizens of the United States as a national security threat, certainly an imminent national security threat. I know I'm throwing lots of different terms that have different legal meanings, Matt, but that is my starting point. And then we look at whether or not there's a statutory basis, that is, has Congress authorized the president to do this? But generally, since the War Powers Act, my view is, hey, if the president's going to do a single strike and he or she determines that there's an imminent threat against U.S. citizens, then there's legal ground to stand on, certainly through domestic law. Let's start with that. I give my legal view, and now you could chop it up.
Yeah. So, and I'll be happy also if it helps to make what I think is the best case that the Trump administration could take. But I like the idea of kind of dividing this into categories. We can talk about constitutional issues first, and then maybe talk about the international law issues. Because I think on the constitutional side, the administration is on much stronger ground. In fact, I'd say under kind of prevailing presidential practice going back many modern presidencies, this fits well within, I'm going to say, the norm. Not that the factual circumstances are the norm, but I don't even think to fit within the practice and articulated kind of formulas that presidents of both parties have adopted and applied in recent decades. I don't think you'd even need to make the case that this was an imminent threat.
Okay.
That presidents of both parties going back decades have taken the position that the president under Article 2 of the Constitution as commander-in-chief and chief executive can use military force in the national interest up to a certain threshold. And this is where it gets kind of fuzzy, but it's often articulated as, if the president used force of sufficient magnitude for a sufficient amount of time, perhaps with sufficient level of risk to American personnel, risks of escalation, and so on, perhaps at some point you reach some threshold where Congress would have to expressly authorize it. But short of that threshold, the president has, under Article 2, a lot of leeway to use force. That's not a uncontested view. There are a lot of members of Congress who would push back, but that has been, I would say, the consistent practice.
Rand Paul is not winning this debate. Rand Paul is not winning this debate. Whatever powers the Constitution gives to Article 1 as a Congress to declare war, we are where we are, and we're looking at certainly the past 2 decades, certainly since 9/11, presidents of both parties have relied on this commander-in-chief authority. All right, but I feel like there's a but coming here.
Well, no. On that, on the constitutional issue, there I'd say the president is on pretty strong ground, and I'd say it's going to be controversial. It always is. When the president used military force unilaterally against nuclear sites in Iran, there was pushback on constitutional grounds within and outside the government, especially among some members of the Hill. And I mentioned the Hill because I would say, to the extent that members of Congress regard this as trampling on legislative prerogative, it's up to Congress to sort of defend its turf, right? And there are things that Congress could do. It often doesn't. It could, on the one hand, it could authorize force in this circumstance, perhaps authorize it with some limits. It could pass resolutions dissenting from that view. It could hold hearings. It could restrict funding. But it's really up to Congress. This isn't the kind of issue that is very likely to be adjudicated in the courts. It's for the elected branches to
yeah, absolutely. It's the political branches, and I do want to just hit on the congressional side, because the Congress, as it relates to targeting terrorists, has contemplated going back and in some ways changing the authority that Congress gave the president after 9/11, the AUMF, the authorization to use military force against Al-Qaeda and its affiliates. But they never were able to do it. Now, we're extending it here to the conversation about drug cartels, and we're making an argument about what's authorized under the Constitution without congressional authority. So we don't even have to go there. But maybe you could hit on, as we're talking about domestic law, the Article 2, Commander-in-Chief authority. The Trump administration has sort of muddied the waters a little bit on this, because they talk about Tren de Aragua as a terrorist organization, suggesting they have authority to do this as a terrorist entity because it was designated as a foreign terrorist organization. How does that play into the domestic law here, Matt? That are they suggesting somehow there's an existing statute on the books that they can rely upon? Why is that relevant?
Yeah, I don't think they are. I think, look, this is an administration. I work for an administration that took a very broad view of the president's unilateral Article 2 power, and there were many members of that administration that kind of preferred to operate unilaterally and really assert a very, very broad view. It didn't always have to do so in the global war on terror, again, sort of more precisely the global war against Al-Qaeda, because, as you said, a week after the 9/11 attacks, Congress passes a force authorization, the authorization for the use of military force, broadly worded. I think sometimes it's misunderstood as kind of this blank check kind of writ, authorizing the president to use force against terrorism worldwide. But it's narrower than that. It's broad, but it's narrower than that. And I like the way that you put it before, Al-Qaeda and its affiliates. So the global war on terror had this legislative basis. The strike we're talking about last week doesn't, and I don't see any claim by the administration that there's some sort of legislative authorization. This is, as best I can tell, a pure presidential power theory.
But they keep on mentioning the FTO designation, the Foreign Terrorist Organization. I guess my question to you: does that add to the authority here in any way?
Not to use force. The administration has labeled Tren de Aragua a foreign terrorist organization. That's a statutory framework. Again, it's quite broad. The executive branch has a lot of discretion to designate groups, terrorist groups, violent groups, as foreign terrorist organizations. One of the main things that then triggers is a set of, for example, criminal and civil penalties for individuals who might provide some sort of material support to those groups. But designating a group a foreign terrorist organization doesn't equate to kind of opening up lethal force as an option. I think you need to make another argument to get there.
Got it. One more question on the domestic authority side, the legal authority for president to use pursuant to the U.S. Constitution and U.S. laws, the connection to Maduro, the connection that, even if it's strained, it sounds like you're somewhat skeptical, that Tren de Aragua somehow is an element of, an extension of this narco-terrorist state, as I believe our Secretary of Defense or Secretary of War, whatever the title is presently, refers to Tren de Aragua. Does that enhance the authority through domestic law? Does it matter whether you're dealing with a non-state or state actor with the use of the Commander-in-Chief Article 2 authority?
I think it matters more to the international law arguments than the constitutional arguments. Though I will just mention, one of the other authorities that the administration has invoked is a statute. Here we may get into the weeds a little bit, but it's a statute that dates all the way back to the quasi-war of 1798. Something called the Alien Enemies Act. And
are we dealing with like the Adams?
We're dealing with the Adams administration.
Yeah.
I mean, you worked on the Hill, so sometimes Congress doesn't really clean the books of some of these.
So we should do a trigger warning for our viewers and listeners that we're about to go really deep and far back. But you're telling me that elements of the Trump administration or advocates of the strike are now going back to 1798 Adams administration, which most people are only thinking about because it sort of rhymes with a Hamilton song from the show. Okay, go ahead.
I'd say not for the strike. This is sort of a parallel effort. There's a statute called the Alien Enemies Act, and it says that in the event of a declared war, or the language is a predatory incursion by a state, a foreign state, that then triggers a presidential authority to essentially deport with very little process.
So we're dealing with illegal.
State.
Yeah, and we've had at least one court strike that down because that was a claim. Okay, but it's you're connecting here because you could potentially say these individuals that were extension of Maduro regime were going to enter the country, and therefore they could add that to the rationale.
Yeah, and these things kind of piece together. I mean, that's essentially an immigration authority, not a lethal authority. But if you step back, where they connect is the Trump administration essentially building a theory or relying on a theory that the United States is at war with Tren de Aragua, possibly in some way also Venezuela.
Yeah, the narco state.
In a rhetorical sense, but in actual, in legal terms, we'd say armed conflict. And that then opens up all kinds of...
Well, we should talk about it. We'll move over to the policy world with this, but I do have one follow-up question on the legal side in a moment. But the Trump administration was very clear on this from the beginning of Trump 47. But even in Trump 45, the president contemplated in a conversation with his Secretary of Defense about targeting cartels in Mexico and wanted to explore taking out cartels through a missile strike. Ultimately, that, well, as at least recalled in Secretary Esper's memoir, persuaded the president not to do that. But that impulse continued through President Trump's election in January 2025. He ran on this, executive order on this. I mean, this has really been cultivated to say the president's worldview is that this is a matter of national security, and he intended to use all the tools at his, kind of disposal to take out these cartels, which, again, in his view, very publicly, is responsible for killing Americans. Now, critics come out, and I'm making policy arguments here, not legal arguments, that, hey, you're never going to stop the supply issue, or even whatever you do on the supply side. You can go ahead and take out as many fast boats as you want. It's in the calculus of the cartels. You need to deal with the demand side. That's a policy argument, and we have to have Americans stop, basically cease demanding the narcotics. But I think from a Trump administration view, they would say, as they do on a variety of other issues, no, we're actually too soft on the demand side. One writer from the Wall Street Journal basically said, we're no longer going to be courteous and, knock on the door of the fast boat with our Coast Guard and say, excuse me, please hand over the narcotics and go on home. We need to treat these cartels as enemies, and therefore a military strike is within the pale. That's the policy argument.
And it's also the legal argument. It's wrong. The legal argument, and here's why. And here's why. Let me sort of make the best case and
Yes.
then explain why I think it's wrong. So, and again, there are a lot of facts that we don't know here. But as a matter of now, I'm talking to international law. We were talking about constitutional law
Okay.
before, but international law I think becomes important not just from a legal analysis, but because I think it's relevant to the policy and strategic considerations here. So you start with, I think, a sort of basic proposition that you can't go around the world whacking people, even the most odious ones. And normally it's been the American practice to interdict the flow of drugs and criminally prosecute the perpetrators. And there are exceptions to that. Invasion of Panama in the late 1980s, for example. But you need some lawful basis for the use of lethal force. And the theory that we see the Trump administration articulating here, and you're right, it's not just something that was really new last week. That was the most, I think, explicit invocation of it.
Yes.
But it's this idea that we are not just in a rhetorical or political war on drugs, but an actual armed conflict with Tren de Aragua. And in an armed conflict, you can target enemy fighters with lethal force. That's like the theory that we used with regard to Al-Qaeda. And we called them enemy combatants.
Right.
Now, I think there's a big difference, though, between Al-Qaeda and Tren de Aragua. It was a controversial move in 2001 to do this, and now we're talking about a big stretch. With regard to Al-Qaeda, I think what put that within the international law frame of armed conflict was the fact that we were dealing not just with a group that threatened Americans, but it was one that Al-Qaeda was able to wage armed violence at a level of sophistication and magnitude previously only achievable by states. It had, over the course of years, declared war against the United States. It had attacked our warships, our embassies, our financial capital, our military headquarters. It had killed thousands of people with the object of actually making war against the United States, not with
Stated
criminal.
explicitly as much. I mean, that was the intent.
Absolutely.
Yeah.
This was all kind of out in the
which
open.
is relevant in
It wasn't trying to make money.
Yeah.
It wasn't trying to make money.
Yeah.
It wanted to defeat the United States. And I don't think we're in that situation now. And I think there's a big difference between the two, especially when you're talking about international law. But I think also when you're talking about policy issues.
Let me debate the international law point for a second. I mean, the basis for that critique, and it's well-reasoned, not surprised that you make a well-reasoned argument here, Matt, is sort of out of the construct of what we've seen out of the war on terror. The basis is about international law for the U.S. carrying out the war against Al-Qaeda, this idea of a combatant and unlawful combatant and the like. But there's also a notion in international law of sovereignty, and that states are allowed to, I would think, to protect their sovereignty, use military force. Again, if you're not going to undermine the sovereignty of other states, that's why the international waters here is relevant. And there's a strong argument to be made, certainly an argument that President Trump, perhaps not using these words, but is sort of the thrust of it, is saying these cartels are undermining U.S. sovereignty and are harming U.S. citizens. I mean, you think about 9/11, right, and the number of lives lost. Tremendous tragedy, but it doesn't compare to the numbers of lives lost due to narcotics come over into the United States by the cartels. I mean, I'm looking up. This is ChatGPT informed, so I don't know if I'm co-piloting sufficiently with my ChatGPT to make sure the data is right. But even if you give me a standard deviation 1 or 2, it's just going to make the point nonetheless. All right, you're talking about in 2024 over 80,000 deaths in the United States due to fentanyl and other narcotics, and the cartels coming from outside the United States are responsible for 98% of them. So this is something that is, without a question, undermining our sovereignty and is a threat to our citizens, which is part of, what it means to be a sovereign country. Where does that stand in the world of international law?
Yeah, I think where it stands in the world of international law is, first of all, international law tries to strike a balance between giving states the right to protect themselves, especially against armed violence. Armed violence is considered, especially since the 20th century, sort of a special category. Balance the right of states to defend themselves with a desire to preserve international order by not giving states a complete license to use force whenever they see it as in their national interest. And there are a lot of things that are transnational. They cross our borders, either physically or virtually, that cause quite a lot of harm. Drugs, criminals, human smuggling, ransomware these days. Not all of them trigger a right of self-defense using military force. And here I would say there are basically two cases in which the United States could freely and could use lethal force. One, as I've talked about before, is if you made the case that this is an ongoing armed conflict.
Yep.
Again, not just sporadic violence, but a state of war, effectively, between the United States and a transnational organization, or in individual cases of self-defense against, you used this term before, an imminent armed attack.
Right.
And here I'd say the Trump administration has actually undermined its own case with the rhetoric of basically saying we could have stopped these guys, but we preferred to
Okay, so now we're getting to the facts of the case.
Message.
Yeah. So
and international law, we can talk about the policy merits of that, but international law doesn't recognize that as a valid use of force.
Got it. Okay. Are we going to see the Trump administration legal rationale, the way the public often gets to this, particularly if it doesn't come before a court and an argument is not put forward by the Department of Justice before a court, which I don't think we'll see here for reasons you outlined earlier. Generally, we'll see some sort of war powers notification. Certainly, we see that for strikes against terrorist targets. Trump administration, at least in first go around, would comply and would send war powers notifications. We saw that with the Soleimani strike, for example, when we took out the Iranian IRGC leader on Iraqi territory. Interesting case in its own right. Not going to go down that rabbit hole. Do you expect to see a war powers notification for this strike?
So we just saw a war powers resolution notification to Congress under the War Powers Resolution of 1973.
So it's out?
Yes, it's out.
Oh, I missed that. Okay.
But it's bare bones.
Okay.
But it's bare bones. I mean, it's what the lawyers were especially looking for was, A, did they notify Congress at all? And B, what did it say at all about the president's the legal basis, the legal authority, and it's Article 2. It's what we were talking about before, but it's bare bones. It really doesn't say a lot.
Nothing about international law, though.
Nothing about international law. And what we often see after the use of military force, especially in a large-scale operation, might be a memo from the Department of Justice explaining the president's the legal basis, the legal authority under which the president acted. I have no idea whether we're going to see one in this case. I think that's a mistake. I mean, here I'd go back to some lessons of the global war on terror, the war against Al-Qaeda, which is I think the Bush administration was very slow to articulate its theory, make the case, the legal case. Understandably, some of this was hard. We were under attack. We were in lockdown. But it was very slow to articulate the case, and I think that was a mistake, both from kind kind of public diplomacy and legal diplomacy standpoint, but also just as a matter of
well, I think
good
it's good the Trump
government.
administration is at least putting out the Article 2 rationale, but
Yeah.
but I take the point that on the international legal grounds has been part of the justification you would have seen other war powers notifications.
Right. Now, I will go even further, though, and say, the Trump administration has almost gone, I was going to say almost, it has gone out of its way in a kind of chest-thumping way to say we don't care about the international law argument. I think it was J.D. Vance used a sort of expletive to make that point. And here I think I would raise a couple of big concerns about that. One is that it's not who we are. We're a rule of law republic. A second one is it's in our interest to try to strengthen some of these rules, not weaken them. And I'm a hard power guy. I'm a peace through strength guy. I don't have some romantic views about that international law and norms are save the world's problems, or that U.S. compliance means that everybody else will. But it matters. But here's third. One of the things that really worries me, especially in the region, is we're engaged in a major competition for influence with the People's Republic of China. And this is a gift to them. I mean, to China, to be able to paint the picture of the of themselves as the responsible power and not the predatory one. I think we're playing into.
Yeah, I'd agree with that. I think there's arguments to be made, and the Trump administration has done this, certainly in their Trump 45, and they ought to do it here. Conservatives have long held deeply skeptical views of international law and its applications, certainly international bodies, the UN in need of deep reform, and even within the Trump administration, you have different approaches. One, just sort of burn it down and not participate, versus no, we got to take it to task and reform it from within. We'll see what happens if and when Mike Waltz is confirmed to be the ambassador to the United Nations, and what happens there. No, I take that point. Let's move on, because from the time that we scheduled this conversation to time of recording, there's been another event, a military strike, high kind of visibility strike, not the United States, but in this case, Israel, carrying out a strike in Qatar, in Doha, against the leader of Hamas's political bureau, Khalil al-Hayya, who they successfully killed in this strike. Reportedly, at the time of this recording, this is something that the Trump administration, perhaps President Trump himself, greenlit. In other words, told Israelis, you won't stand in the way. Qatar is a non-NATO ally of the United States. I think I got that right. President Trump traveled to Qatar earlier this year, signed a lot of deals. Perhaps the next presidential plane will be a gift. He will fly in a gift from Qatar. I mean, there's a lot of deep linkages between the Trump administration and Qatar, and yet we have this strike. To me, it's this idea that there's no place where Hamas is safe, and of course I'm assuming that was the intent of Prime Minister Netanyahu, the Israeli government, and the Israeli Defense Forces, and it's long been a problem that for Israel, that Hamas has sanctuary for its political operatives, a distinction that some in the West make between the political operatives of what the U.S. designates as a terrorist organization versus the military operatives. Certainly in the eyes of Israel, that is a distinction without a difference. As a matter of international law, Matt, and I know you have limited information about this strike, I fully expect not only Qatar but other countries to attack Israel for carrying out this strike on another country's sovereign territory. They've done this in Lebanon. They've done this in Syria. But now they moved over to a Gulf country that has a close working relationship with the United States.
Yeah, I'm going to answer that, but I have to make another comment first, because you talked about
your prerogative. Your prerogative.
That's my prerogative. You talked about international law and the conservative movement and the Republican Party. I do just want to make one other point about the lethal counter narcotics strike,
oh, yeah.
Right? Which is this is a time, you and I have had a lot of conversations about this, where the United States needs to be focused on military modernization. It needs to be focused on rebuilding the defense industrial base. And I really worry that the Trump administration is getting distracted and is distracting the military with a lot of missions that are pulling it away from those core responsibilities. It's counter narcotics, it's border, it's policing American streets, and to me, that's not peace through strength. I think it's a dangerously unserious approach to national defense. I had to make that point.
No, fine, and I'm going to react. Try not to get the last word entirely. Yeah. Maybe this will be another discussion we can have together. Very sensitive to the need for build-up, for focusing on the PRC in particular, and all that. I do think there's value to focusing on the Western Hemisphere in the way that we have not. Whether or not a strike on a cartel fast boat is the way to do it is debatable. But I actually think, given, let's say, the Southern Command, our combatant command that focuses on the Western Hem, a little more firepower, a little more muscle should be part of the rebuild. Take your point, though, that policing missions and National Guard and all that, although more to go on that. Next time we have a convo, let's hit on the Israel strike.
Qatar, look, I'd say, Israel, in the case of Hamas, is engaged in an armed conflict. I mean, it has been for a long time. It certainly has been since October 7th, but this goes back a long way. And the way the United States government has approached a war against a transnational terrorist entity is to say that it can use armed force against its military leadership, its command structure, even in other states under certain circumstances. Because you mentioned sovereignty before, right? And the way that the United States has approached this is to say that when enemy fighters, enemy leaders are operating from the territory of a foreign state, and that foreign state has been unwilling or unable to neutralize that threat itself, then under certain circumstances, we've been prepared to use force on the territory of another state. And the idea would be, if the United States, let's say we're conducting a counterterrorism strike on the territory of Yemen, we'd characterize it as this is not an attack against Yemen, it's an attack against a target in its territory because the government of Yemen was not doing something about it.
Yeah, they let the Houthis operate.
That's right. That's
actually,
right.
My frame of reference here, my first thought when I saw this strike, and I'm thinking about the dynamics of Qatar, which Israel is not at war with, certainly, but they don't have don't have diplomatic relations. They're not an Abraham Accord nation, but the United States and Qatar, as we referenced, do have this close working relationship, military presence there, for example, many U.S. personnel there, which obviously is another reason why Israel would want to coordinate with the United States. I thought of Abbottabad. And Abbottabad, for those listening and watching may not recall, was the location where the U.S. military found, captured, and killed Osama bin Laden.
Yeah,
maybe they didn't capture, but killed and then disposed of him elsewhere. Yeah. And we had diplomatic relations with Pakistan, and that is the United States had to take care of it on its own.
Yeah. Yeah, this is totally different, right? This is totally different. You're talking there are obviously very complex relations between the United States and Qatar, between Israel and Qatar, given its position in trying to mediate ceasefires and so on. And we're talking not about just any enemy leadership figures, but very, very high-profile ones that had been not hiding out in, the frontiers of Qatar, but had been there at the invitation, right? At the hospitality of
at the Ritz or Four Seasons, wherever.
Yeah, exactly. So, this is this is taking that theory I mentioned to sort of a whole new level. If that's even their argument that they were entitled to take the strike because Qatar was unwilling or unable to sort of mitigate the threat itself.
Well, the Qatar clearly made a distinction between political Hamas and military Hamas.
That's right. And Israel hasn't been recognizing that difference in terms of the hierarchy and the way it thinks about who is targetable.
Policy question for you on this strike. Obviously, it's fresh, it's breaking, and you haven't had time to consider it. But on the policy side of the house, Israel has dealt with this sort of problem in the past through a Mossad sort of covert operation. In other words, we don't like this guy. He is undermining, our security situation, responsible for attacks on Israeli citizens. We're going to take him out through how clandestine covert operations generally do, poisoning, some assassination. I mean, you don't have to use your imagination. Just put in Google and you see Mossad operations. This is escalatory in the way they're going about it through the tactics. Take me through the policy sort of implications of what took place here.
Yeah, this is escalatory in that way, though it's it's in some ways it is a Rubicon, I think, that Israel had already crossed, for example, with the strike against Nasrallah in Lebanon.
Yeah.
Essentially, it's like we're in a different world. We're not waging this conflict or this phase of the conflict in ways that we've done so before, and Israel is in a different position than the United States is within our hemisphere. In that, we hear a lot, you and I, in the conversations we have with colleagues in Israel. Israel really felt a very, very strong need, still feels a strong need after October 7th to reestablish, to restore credibility in the region, restore deterrence, and I think one needs, this had to be in a strike that was partly about the sort of the operational implications, but part of it was a big communication to the region that this is how we're operating now, or this is how we may be operating. And obviously a lot is coming to a head now around Gaza City. And so I think this has to be seen as a part of this big push that Israel that the Israeli government is making right at this moment to try to bring an end to the conflict through some sort of victory.
That's a good point. I mean, this has been an area that has been festering for some time. The fact that Qatar, their intentions, what they're actually doing, are they an actor here that wants to partake in the negotiation and contribute to a ceasefire, or as many skeptics, certainly in Israel and in the United States, certainly in some in the Trump administration, feel that they're actually working against peace, working against an outcome here that will end the war and maybe even against U.S. interests. Israel made clear today where it stands on it and has removed that actor, and it is a bit of a Rubicon that's been crossed. Matt Waxman, we're going to have to end it here. Thank you so much for bringing your expertise both in law and in policy as we look at these novel developments in the world of national security, foreign policy, and law.
Sounds great. Thanks for having me, Roger.